Not sure I understood that last answer. I don't doubt 3553A factors are very broad and give the district judge rightly lots of discretion in sentencing when there's not a mandatory minimum. But I wouldn't have thought that one of the circumstances, personal circumstances that a judge could take into account has, as Justice Sotomayor says, really nothing to do with the defendant. It has to do with the judge's own disquiet, perhaps reasonably so, about the jury's verdict. And I had thought in our legal system the jury's verdict on the facts is not something a court can impeach unless it's clearly erroneous.
That's correct, Your Honor. And what I was referring to in answering Justice Kagan is that the judge here, for example, referenced the fact that the defendant had no history of violence,
Sure.
that he was a working man.
All of that's fair game. I agree with you. I'm not, again, I don't question any of that. But the appropriate remedy for disquiet about a jury verdict is to set it aside as beyond the pale. It isn't to say I disagree with the jury about the facts and therefore I'm reducing the sentence, is it?
Well, normally it isn't, but under 3582.
No, I understand your 3582 argument, but under 3553, that's not an appropriate consideration, is it?
It could be a consideration when weighing all the factors, deciding how much weight to give to questions like protecting the public from the defendant or the...
I think in that, protecting the defendant from the public, you have to take as given, again, the jury verdict. I don't think you get to impeach it by saying, I just disagree with it.
Right, but, I agree with that, Your Honor,
okay.
But the question is how to weigh it.
Thank you.
Justice Kavanaugh?
Just one more on the